Welcome to It's a Crime. I'm your host, Margaret McLean. Commonwealth versus Karen Reed. It's really heating up. The big question is, will prosecutors be able to prove that the defendant, Karen Reed, struck her boyfriend, Boston police officer John O'Keefe, with her SUV and left him to die in the snow? In this video, we'll be taking a deep dive into the prosecution's timeline. Do the numbers add up to murder? It's amazing what a difference there is between this trial and last. The prosecution's case is much more streamlined, yet the defense is scoring points with its cross-examinations. This case has sparked so much controversy on a national level. In fact, this week I was happy to be a guest on Vinnie Peloton's closing arguments on Court TV, and I had the chance to really interact with the live studio audience both before and after the show. I don't care which side you're on, I respect opinions from both sides. In fact, I'm trying to analyze this case from a juror's perspective. Prosecutor Hank Brennan has really streamlined his case. Things are moving fast, and I believe that the defense is doing a great job this time around on cross-examination. Let's start with the timeline. In his opening statement, Hank Brennan promised that he would use facts and data to prove that Karen struck John with her SUV. The prosecution's expert, Shannon Burgess, did an excellent job on the timeline. So we know that John's phone and Karen's SUV traveled together. So what he did was he correlated the iPhone with Karen's Lexus. Now this is a key witness and also a very controversial one. In fact, some people would call him cringeworthy, and I'll explain why in just a few minutes. So evidence has already shown us that when Karen was driving her Lexus with John in the passenger seat and they were on their way to 34 Fairview Road, Karen made a 3-point turn. That detail is shown on the Lexus data system and John's cell phone. Burgess explained that the internal time clocks in various devices can be off by a number of seconds, and that's called a time variance. Because the Lexus and John's phone made the same 3-point turn, they have a shared event. The clock variance between the iPhone and the Lexus is between 21 and 29 seconds, so they're off by that amount. As a result, Burgess adjusted the time in the Lexus so it had the exact same time as John's cell phone. He adjusted the Lexus clock forward to synchronize it with the iPhone. Why is this important? Because Brennan wants to make it easy for the jury to see that John's phone and the Lexus were traveling together. Because when Karen dropped John off at 34 Fairview, she pulled the Lexus forward and then backed up at a high rate of speed. In his opening statement, Hank Brennan asserted that Reed's Lexus was traveling at a speed of approximately 24 miles per hour when it struck John O'Keefe. He claims that Reed reversed her vehicle, accelerating to about 75% throttle, and that's when it hit John. He fell backward and struck his head hard on the ground, and that's when he sustained his fatal head injury. I'm going to be explaining this in hours, minutes, and seconds. According to Burgess, the digital expert, the backup maneuver on the Lexus occurred between 12:32 and 4 seconds and 12:32 and 12 seconds. That's 8 seconds altogether. It's a short time frame. That's when Karen backed her car up. O'Keefe's iPhone was locked for the last time during that time frame at 12:32 and 9 seconds. I mean, it fits perfectly. It is the strongest piece of evidence that supports the prosecution's case that Karen Reed struck John with her vehicle and left him there. So what's so cringeworthy? Well, defense attorney Bob Alessi started right out with a bang on cross-examination. He pointed out that Burgess misrepresented his education on his LinkedIn page and on his company's website. On those sites, Burgess claimed to have a Bachelor's of Science degree when he only had a General Studies degree. He never even finished his bachelor's degree, which he started 17 years ago. Alessi certainly embarrassed the witness on the stand, and Hank Brennan must have known it was coming because I noticed on direct examination, he didn't even ask the witness any questions about his education, which they usually do. Now, the defense will make a big deal out of this in closing arguments, saying, how can you trust any of this guy's data when he's misrepresenting himself about his education? Is it significant that this expert misrepresented his education? I asked criminal defense attorney Mike Rusconi what types of checks and balances he engages in before using an expert like this.
We check their work a lot, like if they have anything published, we'll pull up what they published and see if it was peer-reviewed and things like that. That's the stuff you go to right away. Expect the company to catch that in the first place.
That's a good point. The prosecution is using the company Aperture, which provides expert witnesses for digital analytics and accident reconstruction. The company is being paid big bucks. My guess would be over $1,000 an hour for the research and the expert testimony, so you'd think you could rely on the information on their website about a particular expert witness, somebody on their payroll. How upset would you be if you hired this expert from Aperture?
Be furious. I would be fit to be tied.
Another thing that came up on cross was Burgess used a slide that showed Karen and John were at the Waterfall Bar and Grill on January 29th into the 30th, when it was really January 28th into the 29th. So it was a sloppy clerical error, but it made it 24 hours off. Will that matter?
In and of itself, is it the worst thing in the world? No. Now you added the fact that he can't even get the date of the thing he's supposed to investigate. How can you possibly trust his calculations if he can't get something as simple as that correct? That's what you as a defense attorney would dig right into. Something happens in every step of the way in this case. Every time I tell somebody, I'm like, this can't get any more crazy, and then it does. It does every single time.
So let's see how Hank Brennan rehabilitates his witness on direct examination.
You were asked some questions about your CV. A CV is a resume?
Yes, it is.
Okay. And you were asked about a LinkedIn account.
Yes, I was.
Is your LinkedIn account different than your CV?
Yes, it is.
And in this case, when did you learn that your LinkedIn account was wrong or had not been updated? When was the first time you learned that?
That was yesterday.
When you started your LinkedIn account, do you remember when it was you set it up?
I do not. It would have been maybe 10 years ago or more.
Do you routinely update your LinkedIn account?
No, I do not.
Did you ever weigh in or develop your information that was on Aperture's website?
No, not on the website.
You do provide CVs before you come to court, don't you?
Yes, I do.
And in this case, you were asked by the defense, when you provide your CV, do you understand that it's going to be reviewed by whoever requests it, the Commonwealth or the defense?
Yes, I do.
And that it will be shared with both sides in the court?
Yes.
And sir, when you provided this CV to be filed with the court and made public, did you indicate that you had obtained a bachelor degree?
No, I did not.
Why did you put currently pursuing?
Because I am currently pursuing a bachelor's degree.
And did you understand your CV was received by the defense and they knew this?
Yes, I do understand that.
Subsequently, you were asked to provide an updated CV in April 2025?
Yes, I
Did you
was.
further appreciate this would be provided to both the court and the defense?
Yes, I did.
Did you represent to the defense that your education included earning a bachelor degree?
No, I did not.
Brennan went through further certificates and qualifications for the witness that he hadn't listed before, so in my opinion, he built him back up. He also took the opportunity to clarify the most important data. Brennan went through further certificates and...
Do you know from your study what direction the defendant's car was traveling at 12:32:12?
It would have been traveling in reverse.
Mr. O'Keefe's last user interaction with his phone at 12:32:09. Where does that fall within the 10-second window that was captured by the text stream data?
Sure, so that falls within that 8-second window. So again, the text stream event ends somewhere between 12:32:04 and 12:32:12. But that does not represent that the backing maneuver has ended. Just the recorded data has ended.
To a reasonable degree of scientific certainty, did both these events, the last user interaction and the window captured on the reconciled data for the text stream, happen around the same time?
Yes, they did.
That's very strong evidence that supports the prosecution's case that Karen struck John with her Lexus SUV and left him to die in the snow. Once again, thank you for listening to It's a Crime.